Thank you, Mr. President. Colleagues, I rise in opposition to Senate Resolution 388. Almost 200 years ago, Georgians set out certain protections in our Constitution to protect religious freedom. Like in a majority of states, our state provision provides stronger religious liberty protections than there are in the federal Constitution. And it is because of that provision that religion has flourished in the state of Georgia. We should not abandon the protections that have allowed all religious faiths to flourish in Georgia for all of these years. I want to at least add a little bit of color onto the claim about the Blaine Amendment and anti-Catholic animus. The real history of our amendment begins almost 100 years before Governor Blaine. Our Constitution has had some version of our current provision since 1777. The current provision was adopted as part of an entirely new Constitution during the '81 Constitutional Convention. And that's not to say that there hasn't been anti-Catholic animus in our state and in the country. And as a Catholic, I do not think that that's anything to be laughed at or trifled with. However, I do have to correct the misperception that it was solely about anti-Catholic animus. Instead, this language originated 100 years before Governor Blaine started his push. The problem, as I understand it, and why we have this resolution before us, is that religious organizations would like to be able to provide the same services that secular organizations do and get paid by the state the same way. That is a legitimate concern, and it's one that our courts have addressed. In Tatel versus Atlanta Public Schools in 2006, the Supreme Court of Georgia said that sectarian organizations were eligible for state funding so long as the money was used for a non-sectarian purpose. Religious groups are eligible for funding today so long as they play by the same rules as secular groups. So that's a problem that has already been solved. Religious organizations are exempt from their private hiring from portions of the Civil Rights Act, and thus can hire and fire based upon a person's religious beliefs. That's constitutionally allowed, and in fact fine, when they're using their own money. But this change to our Constitution could result in allowing faith-based organizations to discriminate on the basis of religion using taxpayer money. Allowing organizations that provide services the state pays for, because that organization is serving Georgians, allowing them to decide which Georgians to serve, is inherently problematic and could be tantamount to the state picking which of its citizens go hungry, in the case of a religious food bank, who would get a bed for the night, in the case of a religious shelter, etc. The question that I just posed demonstrates that the funding of pervasively sectarian programs is difficult and unworkable. Who will decide which religion is better than the others? How will Georgia afford to provide the constitutionally required secular alternative services to each religious service? Will the state discriminate against, or will it fund minority religions such as Scientology, Islam, and Wicca? Another problem with this is that it would turn all interpretation of state law regarding churches over to the federal courts. And Georgia courts would no longer have say over this very important topic, something that I'm sure causes all of us to raise our eyebrows. It would also allow organizations that have a religious purpose to skip out on the disclosures we require from others. So it would be that much harder to spot when there's waste and abuse. Ronald Reagan said, "Trust but verify." This is taxpayer money, and we need to do both. So we may be opening the door to discrimination and at the same time closing the door to verification. And that's no reason to amend our Constitution. This is a Constitution, I respectfully remind you, that we all took an oath to uphold. Mr. President, I'll yield the well.